The final case today is Mary Helen Broemer against Thomas Carl Broemer. All right, you ready to proceed?
Thank you, Your Honor. Good afternoon. May it please the Court, my name is Caleb Rowland, the privilege of representing Ms. Mary Helen Broemer, the appellant in this case. I'd like to reserve 2 minutes for rebuttal at this point. There are three main issues in front of the Court, and the first two of those issues are pretty intricately entwined. They deal with an award of alimony to the former wife. But essentially, our position is that the trial court erred in imputing income to the former wife based on the evidence that was presented at trial. Additionally, we argue that the trial court erred in awarding durational as opposed to permanent alimony, and also the amount of the alimony that was awarded to the former wife. Here you have essentially a housewife of 27 years who has very significant medical issues that affect her ability to work. The testimony from the medical expert, Dr. Michael Edwards, was that she has what's known as bilateral benign essential tremors, essentially hands shaking. Also that she has carpal tunnel in both of her hands, and that she has depression. Essentially what we're asking the court to do at this point is to remand the case back to the trial court with instructions to enter a final judgment that's consistent with the evidence that was presented at trial. That evidence essentially showed that Ms. Broemer was not qualified for any of the jobs that the former husband's vocational evaluator testified that she was.
So essentially what you're saying is that that there is not competent substantial evidence to support the ruling of the trial court.
In terms of the imputation, yes, Your Honor. And I want to make clear, too, that I'm not asking the court to reweigh the evidence or make credibility determinations here. There is a specific discrete set of evidence that was not presented by the former husband to overcome or to meet the burden for imputation. And in looking at the case law on imputation, in the Leonard case that's cited in our brief, essentially there has to be competent substantial evidence that the court can impute income when termination of the employment is voluntary, and that the individual is kind of pursuing their own interest instead of trying to become employed or better themselves.
So the former wife, it's your position that she was disabled, she could not work anywhere?
In terms of the evidence that was presented to the trial court, none of the jobs that were presented she was physically able to perform. And that's coming directly from not only the vocational evaluator, Ms. Hellier's testimony of these are the jobs that we have.
Well, what about the telemarketer with the headset?
When we were asking about the telemarketing job, my recollection of that evidence was essentially that even with the ability to sit there for some period of time during the day and make calls, one, I don't believe that job was full-time. And two, the effects of Ms. Broemer's depression and or the medication that she would be on to treat that depression would cause issues with concentration, with motivation, with being able to make the, for lack of a better term, be happy enough or outgoing enough to be able to make those calls in an effective manner.
Didn't your client also testify that her plan was to move to Michigan to be near older relatives to act as a caretaker for them?
I don't know if she was going to actually act as a caretaker. Her plan was, and
She said elderly relatives that she
right.
wanted to be with.
Her family lives in Michigan.
Well,
Actually,
isn't that one of the jobs that the employment specialist mentioned was a paid caretaker in Jacksonville?
I believe it was. However, that requires lifting and things like that. What she was talking about in talking about moving to Michigan to be closer to her parents. Ms. Broemer's testimony was essentially that, look, I'm going to be there in case anything happens. I'm not going up there to take care of them, but I want to be closer because they're getting older, and I need to be able to be closer to my family in case anything happens. This kind of illustrates, I guess, the appellant's main point is that you have qualifications listed for each one of these jobs, and some of them require lifting. Some of them require, the ability to use your hands. Which a great example of that was there's a job in, I think, electrical repair, where Ms. Hellier's testifying that you need to be able to use calipers and a soldering iron. If you have these trimmers, there's no possible way that you can do that job. And so, again, it goes to the idea that we're not asking you to make a credibility determination between two dueling experts. It's more, if expert A says she can't do X, Y, and Z, expert B says X, Y, and Z are required, then can the court find competent substantial evidence that that Ms. Broemer is able to be employed in any of these jobs? Another great example, the sandwich maker position. And in fact, when I personally asked Ms. Hellier, would you feel comfortable holding the sandwich if my client was cutting it with the knife? She was not comfortable with that. All these jobs they weren't jobs that Ms. Broemer could qualify for. And that's kind of the issue here, is that I haven't seen a whole lot of case law dealing with the idea of qualifications in terms of physical ability to do these jobs. There's a lot of cases.
The trial judge seemed like he was kind of in a spot here, because basically you wanted him to determine that Ms. Broemer cannot do anything, but you didn't put forward evidence that she cannot do anything. But they had a job and said, well, you can't do that, or you can't do that, can't do that. But are you saying she's totally disabled and can't do anything?
No,
I'm
sure.
What are the trial judge supposed to do?
Certainly. The trial judge is supposed to make a determination based on the evidence presented by the former husband if he wants to impute income to my client. And based on not only the Leonard standard, but Schramm v. Schramm, and I believe there's another case, Stein, that they all deal with the idea that there has to be, and again, this goes back to the idea of competent substantial evidence. There has to be some basis for the trial court to look and say, there is a job available or jobs available. These are the prevailing wages in the community, and you are qualified for those jobs. If there's not, then the trial court's hands are tied. And just, this goes to your point, Justice Roberts, these aren't things that just popped up at trial. The testimony is that our client has had these issues for decades. They were known. And when I was asking Ms. Hellier about some of these sheets that she brought in that are part of the record, that each one of the jobs are listed on, there's a space for a physician to sign off on and say, this applicant is physically qualified to do this job. None of those were signed. Now, her position is, well, that's not what I do. My position is, if you know that she has physical issues, I'm not sure how you can say she's qualified if you haven't dealt with those physical issues in making a determination as to her qualification. And that's kind of where the argument comes in.
The trial judge acknowledged there were some issues, don't you think? I mean, wasn't that the idea behind the 24 months of rehabilitative alimony?
Bridge the gap alimony.
Bridge the gap alimony.
And that kind of goes to our second point, is that she made a determination of what our client's need would be, at least $2,000 a month. She implicitly recognized that there were those issues. However, then she cuts it off at 24 months and says, but only $700 going forward, when there's no evidence or testimony that even if Ms. Broemer gets the treatment that Dr. Edwards was talking about, that she would be able to perform any of these jobs. And in fact, his testimony was actually contrary to that. What he said was, look, I can treat her. It may be that she can't get out of bed when I treat her. I can stop the tremors. There are drugs that allow me to stop the tremors. But she may not be able to do anything if I use those.
But the record indicates your client has never applied for disability or tried to be declared disabled. Is that correct?
That is correct. And again, it's not her burden to do that. In fact, there's another case that deals with essentially the trial court impermissibly shifting the burden to the imputee, I guess, which is Berkeley v. Berkeley. Now, that's a 5th DCA case from 2005. But essentially, what that case says is that the trial court can't say, you have to show me that you can't work. The idea is, this is a 27-year marriage. There is a presumption in favor of permanent alimony. She's worked 2 or 3 years out of 27. She's been a homemaker the entire other time. And if the former husband wants to come in and say she can work, he has the burden to show that she can work. And again, that goes through those factors.
Are there any specific findings by the trial judge that you take exception to?
Absolutely. And these kind of go to the second point on the alimony argument. But the trial court erroneously used the former husband's gross income as his net income. So the former husband made, I think, $5,200 a month, but she labels the $4,100 a month that he had listed as his net as his gross income.
I see that on page 3 of the judge's order. Don't you think that was just a Scrivener's error that she stated gross instead of net?
No, Your Honor, for a couple of reasons. One, she used that in making a determination as to his ability to pay. The second reason is she bolded and underlined it. It seems to me that that's kind of a point of emphasis, that this is his gross amount. The other issue with that is that not only does she make it, does she make the mistake between gross and net, but then comes back and says, by the way, this is going to be taxable to the wife and tax deductible to the husband. So it kind of further compounds that issue that he's kind of getting to double dip on that. The other issue that you asked about, specific findings. One of the findings kind of goes into the idea of the burden of proof here, which was in the amended final judgment, the court basically says the wife claims disability conditions. However, she's never applied for Social Security or disability, and no doctor has restricted her work or found her to be medically disabled. That may be true, but again, that doesn't have any bearing in terms of what the wife had to prove to be entitled to permanent alimony. Our position on this is essentially that the now former husband did not present competent substantial evidence to show that she is employable to a level that would meet the standard of living that the parties enjoyed during the marriage. That goes to one other finding. The trial judge stated that the parties enjoyed a, quote, meager lifestyle and that they lived, quote, paycheck to paycheck. However, they were able to pay off a house completely. They had, I think, approximately $11,000 or $12,000 in total debt. The wife never worked. They owned 2 cars. And there was about, if you take the 2 retirement accounts together, approximately $210,000 in savings. That's not a family that lives paycheck to paycheck. That's a family that has an excess at the end of the month. The final point on this, and quite honestly, I'm just going to be brief on this, is that given the findings that the trial court made, I understand that it's an abuse of discretion standard in terms of whether to award or whether to make an award of attorney's fees and costs. At trial counsel, myself, and Mr. Luca had stipulated to an amount of $20,000 because of the length of the litigation, that was reasonable. And so once we made that stipulation, I understand that the court still has to find that there's an abuse of discretion in terms of need and ability to pay. But given the fact that Ms. Broemer received an alimony amount that is well below what her established need was, I think that you can reasonably find an abuse of discretion in refusing to award that amount of attorney's fees to the former wife. Thank you.
Thank you.
May it please the court, Jonathan Luca representing the appellee, or former husband, Thomas Broemer. Your Honors, this case is actually quite simple. The issues presented to the court were whether or not the wife was entitled to alimony under the statute. The court found she was, and then it was simply a mathematical calculation in consideration of the statutory factors, which include 61.08 subsection 2E, the earning capacities, educational levels, vocational skills, and employability of the parties, and when applicable, the time necessary for either party to acquire sufficient education or training to enable such party to find appropriate employment. The record shows that the wife, through her own testimony, admitted that she was not disabled. She'd never been determined to be disabled by any doctor. That was, I believe, on page 56 of the transcript. She was also asked if she was willing to be trained into a position, and on that same page 56 of the transcript, she said, sure. In reference to the telemarketing and cold calling and using a headset where she wasn't going to be required to use her hands in case the tremors did have an effect upon her employability, she had referenced that if there was a position here in Florida as an auto dialer with a headset, that do you think you'd fit into that position with a little bit of training? And she said she supposes so, but she doesn't think there's going to be anything like that up north. So clearly this was more of a situation where the former wife, as the trial court found, based on the competent substantial evidence presented to her, that the wife did not want to work. The former husband had repeatedly asked her to go to work for the prior 5 years. She refused. She stayed at home, watched TV, and kept a clean house.
Well, what do you say to the contention that the mischaracterization of net income as gross income skewed the whole computation and judgment?
I don't agree. What I would have to state to the court is that that is a net, and I believe it is a Scrivener's error, and the distribution of the $2,000 in the temporary or alimony that was awarded is roughly 50% or 47.8% of my client's net monthly income, which would be an appropriate award given the situation that the wife needs roughly 12 months, according to the expert vocational rehabilitation specialist, to get back up to par and earning at least minimum wages, which is what the court subsequently found the wife should be imputed to due to lack of diligent efforts to become employed throughout the marriage.
So this was an amended final judgment. So was the gross income, was that ever brought up to the trial court's attention at trial or at rehearing?
I would have to refer to my notes. To me, it was not an issue that I raised with the court. Moving along, in regards to the amount of the alimony award, it was clear that the wife's need was $2,000 and that the court fashioned and understood that she was not unable to work, and she could obtain free rehabilitation information and earn that minimum wage within 12 months. The court decided that at that point, minimum wage would be roughly $15,000 per year, which equates to about $1,300 a month. And then with the $700 added in the durational alimony, that would still meet the wife's need, but now she would be self-supporting.
What was the trial court's finding about whether or not she suffered from depression?
The court did not specifically mention that, but she did mention, the trial court Judge McCallum did mention that the wife had claimed the disabilities for those three factors, the essential benign tremors, carpal tunnel, and depression. And the court grouped those and said, although she alleges that, it in effect does not affect her ability to become employed.
So you read that as a finding that, yes, she had those three problems, but that they did not make it impossible for her to go out and earn a living.
That's correct, because the majority, and in addition, the vocational specialist that was called presented jobs, some that required GEDs, some that didn't. And the vocational expert also, I'm not sure of the record designation, but her CV is within the record, and she mentioned in trial court that she has experience in rehabilitating people through Social Security and other specific functions, and there's free help for the wife to obtain her GED, update her computer skills, and essentially adapt to whatever job she would be accustomed to at that time.
Wasn't there a problem with work that would involve a computer that because of her tremor or maybe the carpal tunnel?
That's true as it's presented from the appellant side, and they tried to argue that in trial, but the doctor could not specifically say that she would have absolute difficulty working a computer, but it would be more finite, repeated tasks or learning new tasks that she would have difficulty in. And of course, the doctor is not qualified as an employment specialist rather than just qualified to explain the deficiencies of the wife. And in fact, he could not even opine that she was disabled, medically disabled. When directly questioned, he deferred that back to the court, saying that's a legal definition. And of course, the trial judge, in being able to evaluate and observe the demeanor of the former wife and her alleged tremors and the extent of them in court, was able to determine that the wife was obviously employable. And it's our position that it's not our job to...
So that your reading of the record and the order is that the trial judge found that, yes, she had tremors, but they weren't all that bad.
Correct. And nothing that would inhibit her from being able to become employed. It's my understanding, and it's the...
And yet there's nothing said to that effect in the order. But do you think that's the only way the order can be read?
I believe that there could be a more detailed finding, but based on the evidence presented, which I believe is competent and substantial, was that the wife was employable, and according to the statute, whether there was a job immediately available for her or that the court considered the necessary time for the former wife to obtain the necessary skills and training. That was the issue here. It's our position that we're not required to place the former wife into an immediate job, given the direct and clear language of the statute. We either present her earning capacities, educational levels, etc., or we have an employment evaluation come in and say, right now she's not employable at this point, but in this case, we've set forth certain positions she could do, regardless of having her GED. However, with a little bit more training within a year, she'll be right there up to par, earning 15, in fact, as the opinion went from the expert, more than $20,000 per year with that adequate training. In regards to the issue of durational versus permanent, it's our position that the court was within its discretion, according to the statute, may award durational or permanent, and the extent of that was 18 years. And the former husband and former wife, based on their ages, right at 18 years, the former husband would be retiring. So that would set up for the former wife, as she was becoming employed and working, that when she sought retirement at about that time also, that they would both be on Social Security, so that would be an automatic, the need would no longer be there for her to be supplemented on her income. Like I said, I believe the amount is correct, and in regards to attorney's fees, the court started with equitable distribution. The major asset of the parties was the home. The wife said she didn't want it. The house was to be sold, and the $161,000 built up in the former husband's retirement account was equally split, as was the majority of everything, except for the household furnishings. The wife took the majority of them.
Let me go back to the alimony.
Sir.
What's your argument again that it should be durational and not permanent? It was a 27-year marriage.
Oh, I apologize. The 27 years, and the age of the wife was 52 at the time. And my argument was only that it's discretionary with the judge on, according to the statute, on whether she may choose durational versus permanent. And I know the statute says that permanent is appropriate, or durational is appropriate in long-term marriage. I apologize, Your Honor, for referencing that.
The judge made a finding on page 2 that this was a long-term marriage pursuant to 6108.
That's correct. In 6108 subsection 8, permanent alimony may be awarded to provide for the needs and necessities of life as they were established during the marriage of the parties for a party who lacks the financial ability to meet his or her needs following a dissolution of marriage. It may be awarded following a marriage of long duration if it's appropriate upon consideration of the factors set forth in subsection 2. Following a marriage of moderate duration, if such an award is appropriate based upon clear and convincing evidence. But if you go back to durational, it says that it may be awarded following a marriage of long duration if there's no ongoing need for support on a permanent basis. So I can only presume at this point, if the parties are in their 50s, that 27 years later, there would definitely be that Social Security aspect.
Can you point to any findings that the judge made to justify this type of alimony versus permanent?
No specific findings. I can only refer, just as the statute does, that in consideration of all the 61.80 subsection 2, it's taken as a whole. And the court looked at that as a whole and then made that determination.
Were any of these jobs that she'd be more likely to get with a GED or would be better trained for by obtaining her GED?
Most certainly. The majority, about 60% to 70% of the jobs referenced they would like a GED. It's the standard across the United States and across the world. The more education you have, the more likely you're able to slide into a position, because they believe that you can obtain a certain status or standard education-wise, and then obviously be trained laterally for whatever position she would apply for. As stated in the trial court, I believe that Mrs. Hellier, who was the vocational expert, testified again that with the training or the GED, or even applying for the job and at least discussing her qualifications, her prior qualifications in quality assurance, or in, I believe it was a stock room, then she might get her foot in the door. That's why, as an alternative, it was set up for the 12-month rehabilitation, taking advantage of the free state programs to get herself into a self-supporting nature. And I'm not sure if I concluded on the fees, but in that regard, with the equitable distribution scheme, as the court found, the parties were placed in substantially similar positions. And as stated in the brief, when that is the case and the net income is equally distributed, minus $100, $139 towards the former husband for the next 2 years, that an award of alimony.
Well, now, I mean, this is the second time you have made that claim, but of course we know that the income tax consequences of that split will mean that there won't be an equal division of net income.
That would be true, and we're taking her $2,000 and taxing it, and presuming even if the husband's income increases over the years. But durational alimony is not confined in a non-modifiable. It's only non-modifiable in duration, not amount. If in the event the wife finds that her needs are not being met adequately based upon the findings of the court, she can always reapply for the substantial change in circumstances and increase versus the husband claiming for a decrease of her needs. Back to the position of the substantial equitable distribution, where we believe that they were put in substantially similar positions, that we believe it would be an abuse of discretion for the court to have awarded attorney's fees to the former wife, because of the retirement was equally split, the homes to be sold and equally split, and the former husband is still required to make the payments on the home pending the sale of the house.
All right, now, the stipulation to the attorney's fee, was that contingent on a particular equitable distribution?
The stipulation from counsel's position and the former husband's position was to stipulate to the amount of the fees. The need and ability to pay would have been something that would have had to been actually heard by the court. The first judgment that came out said the wife was only getting 12 months of $2,000 a month. I filed a motion for a hearing alleging several errors, and the court came back and added in an additional 12 months of $2,000 per month, which might have been the court's reconsideration and offset, given the substantial competent evidence that she only needs 12 months to rehabilitate, but we're going to give her 24. That's $24,000 versus the award of $2,000. I can only presume. I have nothing in the record to actually apply that to, but in the overall logical distribution scheme, it makes sense.
Your client paid some interim fees, is that correct?
That is correct, and that was out of what I would call a pre-distribution. He had a second retirement account or investment account that was liquidated, in which he had to pay the wife half of that.
And the judge ordered your client to finish paying that portion he agreed to as interim fees?
That is correct, a balance of, I believe, $1,600.
So your client has paid about $9,600
That was the original award.
of the
yes.
$20,000?
No, I believe that was different from the 20. No, you are correct, Judge. You are correct, Your Honor. Are there any more questions from the court?
I don't think so. Thank you very much.
Thank you, Your Honors.
Your Honors, I'll be brief mainly because the clock is telling me to. There were a couple of questions here about whether the gross versus net was ever brought up to the court. It was in our motion for rehearing, and it should be at the record. I actually didn't cite the record citation in the brief. It should be right around 290 in the record. But we brought up the fact that we think that the court may have kind of overlooked that in issuing the initial final judgment. Then the amended final judgment comes out and it's the exact same language. The trial court clearly intended the $4,100 and change to be his gross income, at least in her estimation of it. A couple of things about Ms. Hellier that are in response to the idea that these jobs were available and that she could become trained for them and things like that. In the trial transcript, and we cite the trial transcript and the record separately in our brief just because we kind of had to. Once the record was created, it didn't have the trial transcript in it. But at 133 in the trial transcript, Ms. Hellier admits that the former wife would need pretty extensive treatment and therapy to qualify for the jobs that she's discussing. Then also at the transcript 142 and 143, Ms. Hellier also states that all of the jobs that she's talking about during the trial, Ms. Broemer's ability to do those are contingent upon any limitations that a doctor would put on Ms. Broemer. That's all I have. Thank you so much.
Thank you. Court is in recess.